The notification of demonetization cannot be struck down is what Justice Gavai has said.
Well, yes, Sneha. Justice
Yes.
Gavai has very clearly said that the notification of demonetization cannot be struck down. But the issue of what will happen to those persons who still have demonetized notes, whether they can be given any relief, has to go before a larger bench of the Supreme Court. So there are 2 points that have been effectively 2 lines of verdict from coming in from Justice Gavai, that the power of the centre did have the power to demonetize, that the decision was taken in consultation with the RBI, and as far as the RBI is concerned, it does not have the power to accept the demonetized notes beyond the time limit that had been prescribed by the government. But as far as the issue of whether there can be any relief for the people who still have demonetized notes is concerned, Justice Gavai has referred this matter to a larger bench of the Supreme Court. And as we speak, Justice Nagaratna is speaking out her opinion of in this particular matter. And as we said, we've been reiterating this. These are 2 separate opinions being read out. At this moment, we do not know whether this is a split verdict or whether this is a 4:1 verdict. But it is very clear that at least one verdict, one opinion here coming in from the Constitution bench is that the notification was not flawed, that the demonetization decision was correct, that there is no, that the time period provided for the people to exchange their money was in fact correct. Back to you.
All right, the matter referred to the larger bench on the issue whether the people who still have demonetized notes, what are they going to do? What is the kind of relief that they should be extended? What is the kind of relief, Anisha, are they expecting really?
Well, sir, that is the big question now, that if since the Supreme Court is saying that a larger bench needs to be considering what will happen to those persons who still have demonetized notes, has to be sent to a larger bench. Remember, the petitioners have been saying that the people who still have demonetized notes because they were either out of the country at the time or were ill or had some reason were not able to get the notes exchanged in time should be given some sort of a relief. That aspect has been referred to a larger bench. However, as far as the main issue is concerned, the centre's decision to demonetize has been upheld by Justice Gavai's opinion, where he has said that the notification of demonetization cannot be struck down, that the RBI did not have the independent power to accept the demonetized notes beyond the time prescribed by the government notification. The court has also said that the RBI cannot decide on demonetization by itself. It does not have independent powers. And as we speak, the court has also said, in Justice Gavai's opinion, that the Section 26 of the RBI Act has inbuilt safeguards. There is no reason to strike down that particular specific provision that had provided for the demonetization powers. Now, as we speak again, Sneha, I will reiterate that Justice Nagaratna at the moment, even as I speak, is giving her opinion on the particular matter. Justice Nagaratna is saying that she differs on certain reasoning and conclusions given by Justice Gavai, that the Justice Nagaratna in fact has very clearly dissented, saying that Justice Gavai's judgment does not recognize that the RBI Act does not envisage demonetization by the government. Now, this is a very, very crucial observation given by Justice Nagaratna, where she has said that the recommendation has to be initiated by the RBI and not by the government, that there is an importance of the RBI and the RBI Act. And Justice Nagaratna, as we speak, is reading out her opinion on this matter, or the parameters of the entire exercise, whether the proposal for demonetization emanated from the centre or from the RBI. All of that is now being discussed by Justice Nagaratna. Now, remember, this is a very crucial point in this entire argument that was made by the petitioners, because the petitioners have been saying again and again that the demonetization exercise was incorrect, because it was not the RBI which had proposed demonetization, it was something that the government had proposed. Now, Justice Nagaratna, as I speak, is discussing this entire issue of Section 26 of the RBI Act, whether the proposal for demonetization had come from the centre or from the RBI. She is also talking about the origination, or like where exactly did this proposal originate from, and what the law specifically says about this particular issue. Now, remember, as we've been discussing, these are various nuances of the law, of the policy, and while Justice Gavai has very clearly given a clean sheet to the government, Justice Gavai has very clearly said that there is no need for judicial interference, the notification does not need to be struck down, the Act does include its own inbuilt safeguards. Justice Nagaratna seems to be dissenting on that particular point.